Sidebar, Bracewell's podcast devoted to government enforcement investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your host and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions.
Welcome to the podcast, everyone. Our special guest today is an old friend and former colleague from the government. Sid Kamaraju is joining Matthew Nielsen and I. And Sid, I'd like to invite you to tell our listeners a little bit about your background, the background that we shared, and how surprised we both were to recently discover that experience with litigating classified information has become suddenly of great interest to the broader public, and that there may actually be important opportunities for lawyers on the private side now to become very savvy about these issues in certain practice areas. So first, welcome to the podcast. Great to see you again. Thanks for joining Matthew and I today.
Thanks, Seth. It's great being here with you guys, particularly sort of, as you said, a moment where there's great public interest in some of the nuances of classification process. As you mentioned, I was prior to joining private practice, I was a federal prosecutor here in Manhattan at the U.S. Attorney's Office of the Southern District of New York. Like you, I spent most of my time there doing national security work, which ranged from domestic terrorist attacks to foreign terrorism investigations, sanctions investigations, cyber hacking, espionage, a whole gamut of things. And as I'm sure we'll get into, all those kinds of cases and more implicate classified information and the ways in which classified information can be used in criminal prosecutions. I think as we're seeing, it's a very complex process, and it's spilling over into a lot of areas that are relevant for private sector attorneys. So I think it's a really interesting thing to be talking about these days.
Yeah, and if you don't mind, I know lots of people have gotten their advanced degrees in the categories of classification through Facebook and Twitter. But perhaps for those that not so fortunate, let's just start with a little bit, if you would talk about what are the categories of classification of information? What do you need to do to get clearance at various levels to be able to review that information?
Yeah, absolutely. So the classification system in the United States is a tiered one. And as you can imagine, sort of the more sensitive information is, the higher classification it gets. So the lowest level of classification is what's known as confidential. And then it proceeds from there to secret, top secret. And then there's another layer on top of that that's commonly referred to as SCI, or sensitive compartmented information. And basically all U.S. classification decisions are made on what's known as a need to know basis, right? That's written into the law, where a person is not entitled to receive any form of classified information unless they have a true, legitimate need to know it for purposes of national security. And so in order to gain access to any type of classified information, you have to get a security clearance. And we can talk a little bit kind of about the painful process that it is to get a security clearance. But the first step in that is demonstrating that you need access to the information. The other thing to remember about classification is, and the different tiering levels, is it's all based on what disclosure of that information would do to national security and the level of harm that would result if that information came out. So, secret information obviously would be harmful. And it elevates from there until you get to TSSCI, which would pose a grave threat to national security if it was ever released. And so the purpose behind the classification tiering is to try to make sure that as few people as possible know information that could be harmful to the U.S. if it were released.
Yeah, that's a great overview. Thanks, Sid. And a lot of these terms are being, tossed around in the press now. And the mere fact that a document is classified, let's say at the secret level, and one could debate, what really is the difference between causing, grave harm to national security and extraordinarily grave harm to national security. It's a tiered process, but certainly the higher the classification level, typically the fewer people are given access to it, right? And the concern about steps that can be taken to mitigate the disclosure of that information becomes more important. And, look, you're a federal prosecutor. I think some folks, may either presume that federal prosecutors can see all classified information, or they presume that federal prosecutors should see no classified information, right? So you talked a little bit about the need to know, and in adversarial litigation, there's the concept of discovery and government's obligations to produce information, the right to put on a defense. When you talk about need to know in the litigation context, who are the stakeholders, and how can you, litigate responsibly within the bounds of the Constitution, and also protect national security equities for people, who aren't really in the litigation business, from their point of view.
Yeah, it's a challenging balance to strike, and I think you have to you hit the nail on the head with. There is obviously, when you are engaged in criminal prosecution, there are constitutional protections that a defendant receives that trump any executive order or any statute. But at the same time, there's a real tricky problem that if you don't create some mechanism by which you can balance those constitutional rights, and we'll talk about those in a second, versus the need to protect national security, truly serious crimes may go unpunished and undeterred as a result. And so, what when we talk about the constitutional protections that apply, it could actually hit at different stages. So, for example, the Fourth Amendment may be implicated, right? And you see that when the Fourth Amendment typically in the criminal process involves when the government conducts a search, whether it's pursuant to a search warrant or whether they're obtaining in the classified setting, additional sort of investigative methods. The Fourth Amendment governs the reasonableness and appropriateness of that search. And often in the national security space in particular, the lines get blended between law enforcement and intelligence agencies with respect to how the government may come across a certain amount of information. And so even during the investigation stage, and Seth, I know you've had many conversations with agents over the years about, if we're going to do this, what does it mean in terms of what we're going to have to turn over for classified discovery? Right. Even in those moments, you've got to think really hard, because there's going to come a time when there's a criminal charge with a criminal defendant who is going to look to litigate the appropriateness of that search warrant. And for example, if there's classified information about the reliability of a source that may not have been disclosed in a search warrant affidavit to a judge, that could be something that's going to trigger, a further inquiry into it. So like even in the investigative stage, prosecutors are constantly thinking about, how do I protect classified information? Because certainly for national security prosecutors, and I think as I'm sure get into prosecutors who do a number of different kinds of cases, that balance, is one that they're sort of charged with striking. And it's not always their decision, right? Because the information that's being protected very rarely belongs to the prosecutor. It usually belongs to another agency who you are politely begging to be able to use it, right? So you have to be very careful, and I think in investigations across the country, you see prosecutors kind of taking steps to protect and to minimize unwarranted disclosure of classified information. But once you get to the point where you have a criminal prosecution, there's a whole set of constitutional principles that make this a pretty tricky dance. I think one broad category that I'm sure you guys have talked about in other podcasts is just the concept of the government's Brady obligations, which hit at all different stages of the prosecution. But just as a brief refresher, under the Constitution and the case law surrounding the Brady decision, the government is essentially obligated to turn over any information to a criminal defendant that is helpful to the defendant's defense or otherwise undercuts the government's case. That includes evidence that can impeach the credibility of a government witness. And so when you are dealing with routine investigations, say even investigations that don't have classified information in them, there's always a question about how broadly the government's obligations sweep. Where do they have to look, frankly, for all of the sort of potentially helpful information? But when you're talking about a national security or sort of a high-level international investigation, now all of a sudden your obligations as a prosecutor may stretch much further than just the FBI or the DEA. They may go all the way to the CIA or the National Security Agency or Department of Treasury. And so when you are dealing with questions of Brady disclosures and Brady obligations, prosecutors regularly find themselves confronted with having to review the files at intelligence agencies, having to figure out what's out there in the world that may be useful to a defendant because they have that defendant has a constitutional right to that information.
Right. And I mean, let's talk just a little bit about to set this up, because obviously you have issues of disclosing sensitive information. It may be, first of all, to the prosecutor because they may not have full clearance. But then you're talking about disclosing it to defense lawyers, the defendant. You may have instances where, obviously, if you're having to use it in your defense, it may have to be brought out in open court. And we'll talk about the procedures that are there to protect against that. But let's talk a little bit about, if you could, just what are the levels of clearance and what does it take to get those? And are there any shortcuts with any of the various levels of classification that can help, shortcut some of this, like a non-disclosure agreement, for instance?
Yeah, sure. So Seth mentioned before sort of the idea that some people view like federal prosecutors as having access to all the classified information in the world. It's actually that when you start out as a prosecutor, you have access to no classified information. and if you walked in and asked for it, they would laugh at you. So what you have to do, whether you're a prosecutor, whether you're a defense lawyer, whether you're a law clerk to a judge, though not a judge, by the way, but whether you're a law clerk to a judge, is you have to submit for a security clearance process, which is a pretty thorough background check. And it's typically conducted in the first instance by the FBI. They're looking for anything in your background that could suggest that you could be, for example, compromised in such a way that you will one day be sort of threatened or cajoled or otherwise enticed into disclosing classified information. And the level of background check that you receive sort of escalates in relation to the sensitivity of the information you're trying to get. So you may, for example, when I started out as a prosecutor in the national security space, the first clearance I got was a secret level clearance. And it's because the information that I needed access to was only at the secret level. And so they weren't just going to give me the top secret level until I could show them I actually needed it. So, they sort of, even though as I think has been widely reported, there are, I think, more than 1 million people who have top secret clearance in the United States right now. It is still something that they don't just kind of hand out. You have to walk through the process. And then ultimately, as you get higher and higher sort of in the classification levels, the scrutiny becomes more intense. And that's the process for, like I said, a prosecutor or a defense attorney. Either way, if you want access to classified information in the course of either prosecuting a case, investigating a case, or defending a case, you're going to have, step one is you're going to have to be vetted and get approval from, the various constituencies to be able to access that. That goes even a step further. We talked about top secret and SCI information. SCI, or sensitive compartmented information, is the most restricted classified information that there is. And it's basically a reference to a broad category of programs that are each very specific and that you have to get access to specifically to each one. So just because, Seth, I know had a TS SCI clearance for a long time, just because you have that doesn't mean you automatically get access to every bit of classified information out there. So it is, it's a process by which you have to make a very clear showing that you truly have a need for it. And that can be a contentious process, particularly when you're a defense attorney.
Yeah, I think need to know really is the driving principle, Matthew. A lot of people are disappointed to learn, after getting the clearance, it does not allow them to just, flip through the files, so to speak, or invite themselves to every meeting or make any, document request that comes to mind. And even if you're eligible for clearance, like Sid, I'm sure you're still within scope. I had a client, I was still within scope, and the clearances could be reactivated, but they're very limited. for the specific matter that they've been reinstated for. So while it's useful to be within scope on those clearances, it's still a very incremental process to get access to the information that some other person is ultimately probably going to determine whether you need to know or not. And that's, that is the stakeholder who owns that information. And that can be a delicate process. I think, you have a say in whether or not you need to know. And certainly federal prosecutors and other lawyers, can be good advocates within, a particular litigation as to why they have a need to know. And then the owner of that information, can keep an open mind about that. But it's very, very hard, if not impossible, to compel, the owner of that information to give it to somebody when they, in good faith, believe that there will be harm to national security and there is no need to know within their world.
So, Seth, what was your need to know rationale when you asked to see the Lee Harvey Oswald file when you got your clearance? I want to see it. I finally get to send it over, please.
Wildly curious. Yeah. That and I wanted to see the alien bodies, right. That we kept in the vault. But mostly that was just curiosity. And it was kind of a right place at the right time thing, Matthew.
It's fascinating.
Yeah. So, look, we've been talking a little bit about, this in high level concepts, need to know, clearance, Brady. So, those things I think will resonate with our audience. But, when the rubber meets the road, and let's say there's a judge involved, right? And judges know Brady and, judges are accustomed to adversarial litigation and persuasive arguments. But either fortunately or unfortunately, I guess, depending from your point of view, there actually is a statute that applies to this very thing that tries to balance the needs of litigants with the need to protect national security information. So can we talk a little bit, about the role the judge plays and in particular, how this SEPA statute plays out? I mean, it's not a secret statute, right? Most people never bother to pull the book off the shelf and look at it because they don't have a particularly need to. But you can, and you don't need clearance, to read SEPA.
That's right.
It's hard, defense attorneys have complained to me when I said this on the government side. I said, hey, there's no secret. You want to know how SEPA works? You just read the statute. You want to know how FISA works? You just read the statute, and I got some very hostile looks about, it's one thing to read the statute. It's another thing to understand what's actually happening in these skiffs. When you guys are pouring through this stuff and it's like litigating in the dark. I'm a little bit more sympathetic to that argument now that
it's
we're
amazing,
on this side.
How that changes, right?
Yeah, a little bit. So, but SEPA, you can look up SEPA and declare yourself an expert on litigating classified information under the plain meaning of the statute. So maybe we should talk about that a little bit, Sid. How do you work your way through the many, exciting steps of a SEPA adventure?
Yeah, absolutely. So SEPA, which is the Classified Information Procedures Act, is basically a codification of a set of rules and procedures that tells litigants and the court how to handle classified information. And it kind of, and you can see this, and I think to your point, Seth, you can read it on the page that it kind of is a cradle to grave kind of explanation for how to handle classified information, but as with everything, the devil's in the details. What SEPA was designed to do and what Congress intended to do when it passed it was to address, one, the balancing act that Seth was talking about, right, between a defendant's constitutional rights and criminal prosecution. And in particular, also to address a problem known as gray mail, which is a term that's used to refer to when potential or actual criminal defendants essentially threaten the disclosure of classified information or to seek to disclose classified information in order to deter a criminal charge. So as you can imagine, there are instances where defendants are in possession of classified information that the government would rather they not speak on and disclose publicly. And so there's a particular problem in those kinds of cases that if a defendant says, look, I'm just going to spray it all out there. If you bring a charge against me, it effectively precludes criminal charges in some of the most serious cases, right? Whether it is a terrorism offense. And Seth, I know you dealt with that issue in one of your prosecutions, or, I prosecuted a former CIA officer where you can imagine that kind of thing comes up all the time. And so what SEPA does is it sets forth a different process for how the government can approach classified information. And the first step in any litigation that involves classified information is the government will get a protective order pursuant to SEPA. And it's a protective order in the same way that you would expect in any criminal prosecution where it governs the disclosure of information, except in this case, it's specifically tailored to how you handle classified information. And that can include restrictions, obviously, on who can see it, only defense lawyers with the requisite amount of clearance. It can place restrictions on where that information can be seen. So in many courthouses, there is a defense SCIF. And, for those who don't know, a SCIF is just a fancy room with a lock on it where top secret classified information is stored and you need to have an access
or
to
a not so fancy room, Sid.
I'm about to say, I'm going to go with completely unfancy, just say, windowless.
Not all those rooms are as fancy as one might hope.
Yeah, that's right.
I think some of them were broom closets.
In my experience, the government makes sure you're really comfortable whenever you're reviewing documents in their facility. I mean, I know you guys went to great lengths to make sure everybody had comfy chairs and all that, but air conditioning was on.
I used to
fantastic.
I asked for their favorite snacks whenever I could.
Fantastic.
But So the SEPA protective order is sort of the first stage of any one of these things, and it's just going to govern how it is. And I think, when we talk about on the defense side, litigating that, actually being familiar with the SEPA protective orders is a pretty important part of the practice, because if you're going to be dealing with classified information, you need to make sure that you know sort of what the bounds are, but also what you're sort of allowed to use and how you can use it, right? Because you're going to be, in these kinds of cases, writing, for example, classified letters, classified motions, things that discuss or disclose classified information. And so it's really important, I think, for defense counsel to really familiarize themselves with kind of how that process works and what the protective order looks like. And to try, though there's not a lot of wiggle room, but to try to negotiate provisions in it that are tailored to your case. Now, I will admit, as a prosecutor, I wasn't very friendly to those negotiations, but certainly now that I'm on this chair,
in your practice, and you've thought through it. Yeah,
I have. I've thought through arguments of fairness and equity a little bit more clearly these days. But
and also risk. I think Sid, we talked about the realities of litigating with classified information. Look, it's not. The government SCIFs are not a whole lot more comfortable than the defense SCIFs, if at all. I'll just say, and some of them are less comfortable. So, in a world now where people are used to working from home and you just, phone in from your country house, that's just not happening. If you're dealing with classified information, you're locked in a room. And then these warnings that you get, whether you're the government or the defense attorney, I mean, you essentially sign on and say, I understand it's a crime.
Right.
If I unlawfully, retain or disclose national defense information, and I'm agreeing to respect that, and I'm on notice of that. And I remember having conversations with defense attorneys where, we made classified disclosures to them, and it tied them up all in knots because they said, we had a defense investigative plan. We were going to go interview witnesses. Now we have seen these facts. We know we're not allowed to disclose these facts, without permission. How do I know, how can I be comfortable in my own mind that a question I ask or an investigative step I take is not somehow accidentally, inadvertently in violation of this thing that I promised to do? And I think the only answer to that question, and look, we had to think about, the same thing as lawyers for the government. You've got to analyze every step you take in a litigation, and you've got to have a good response, to that answer. But the only point I'm trying to make is that it's hard at every step of the way to analyze, what you're doing, think about your arguments ahead of time, think about what you need to disclose or ask for permission to disclose, and still protect, whether it's the government's case or the defense case, protect from over disclosure because you're worried about the risks associated with the information that you've got to deal with. So, I think I was somewhat sympathetic to that at the time. I'm now perhaps even more sympathetic to that because you want to do a good job. You don't want to get in trouble.
Yeah, that's absolutely right. And I think the the way SEPA is structured adds an additional level of complexity, which we'll talk about, because the SEPA process often requires defense counsel to reveal defense strategy before they might otherwise do so in a case that doesn't involve classified information. And so
for the need to know, right?
As a defense lawyer, yeah, right. And for the need to know, and then also, as we'll talk about it, when you are trying to advocate for being able to use classified information in furtherance of your defense. So there is a strategic element to it that just doesn't, I think, appear in sort of, we'll call them, cases that don't involve classified information. So you have to think that through. And from the government's perspective, the government has a similar challenge, because there is often fantastic evidence against a defendant out there in the world that somebody has that you would love to be able to use. And you know that it's going to be the thing that puts the nail in the coffin, but you just can't. Right. And it's there, but you have to resist the temptation to doing anything that opens the door to the disclosure of that information, even though it's tantalizing. So the injection of classified information, I think, really does make it a more complicated strategic question sometimes for how you're going to present these investigative techniques.
Thank you for joining us for this episode of Sidebar. Watch out for episode 2, which will be coming soon, where we get the second half of our discussion. You can get this episode and others off of the Bracewell website and anywhere else you get podcasts.